Yes, yes.
Yes, ma'am.
So in so in the last class, I had discussed, just giving a brief review of what I had discussed in the last class. If you remember, I discussed about the industrial disputes, right? I discussed. Let me switch on the fan. I just wait for a sec. Hmm. Yeah, I discussed with you about the industrial disputes, like what are the different provisions of industrial dispute, why that happens, what are the reason for that, right? I've discussed with you the different preventions of industrial dispute, how the industrial disputes are being resolved by different agencies or by different bodies. Like if you remember, I discussed about the standing orders, code of industrial, I discussed about the work committees, joint management council, suggestion scheme, joint council, right? Collective bargaining, labor welfare offices, and tripartite bodies. So these were the different preventions of industrial disputes I discussed. I'd also discussed with you about the different machineries for settlement, like broadly, I discussed conciliation, arbitration, and adjudication. So today, I've selected a topic which is going to be also relevant for you and important for you also. Um, that is Workers' Compensation Act 1923, right? So, if you can see, I've mentioned a lot of things in the slide. I'll just read out that and I'll explain. So, Workers' Compensation Act 1923 provides for the payment of compensation to the workmen and their dependents in case of injury and accident. So, Workers' Compensation Act, what does it mean? It means that if the worker, whosoever is engaged in an employment activity, got hurt or get into some accidents, then if that accident is causing some disablement or even the death, then what are the different provisions under the law which will benefit the dependents of the worker? We are going to discuss this thing. So this act actually applies to the railway servants and the persons employed in any such capacity as it is specified in Schedule 2 of the Act. So Schedule 2 of the Act actually properly describe that who are those persons who are going to be covered under this schedule. Okay, so in Schedule 2, it includes in Schedule 2, it includes person employed in factories, mines, plantation, mechanically propelled vehicles, construction works, and certain other hazardous occupations. So you can, by looking into the list, you can just make a guess that the person who are involved in the production or manufacturing process, they are more exposed to the risk of accidents or risk of disablement. Okay, if the person is working in a factory or in a mines, obviously the workers, they will have to handle those machineries which can cause some accidents, right? So in that way, those hazardous occupation will actually provide the provision of compensation to the workers who are involved in that. Now, the amount of compensation to be paid depends upon the nature of injury which has happened and average monthly wages and the age of workmen. So you can see there are three things which I have written. Like first thing is that how much monthly salary the person is getting. So and what is the severity of the accident or the injury which has happened, and the average monthly salary of the person. So minimum and maximum rate of compensation payable for the death. In such case, it is paid to the dependents or workmen, and for disability have been fixed and is subject to revision from time to time. So whatever amount the dependents which are going to get, that is subject to revision. So from time to time the amendments are there, and the maximum amount or the rate of compensation is actually fixed on that. A social security division has been set up under the Ministry of Labor and Employment, which deals with framing of social security policies for the workers and implementation of various social security schemes. It is also responsible for enforcing the act. So you can see that there is a separate division that which is known as Social Security Division, which are actually set up under the Ministry of Labor and Employment. And actually, this is the body which actually frames the different policies and the schemes under which the workers are going to get the benefit. Okay, so this body will also take care as what are the amendments that are going to be there, and how, to what extent this law, this act will cover the various accidents or the cases. Okay, so the body is also responsible for enforcing of this act. Which act? Workers' Compensation Act, right? Moving to the next slide. Object of the act. Object means the objective of the act. The object of the act is to impose an obligation upon the employers to pay the compensation to the workers for accident arising out of and in course of employment. So if the workers will met with an accident, or in any case is injured during the course of employment, then this act will be applicable to that worker, right? So if any accident which is happening because of your own mistakes or because of your own reasons, that will not be covered. So if you are engaged in the employment activity in any way, and if you are doing some work in the factory premises and some accident has caused, that will be covered under this. So the scheme of the act is not to compensate the workman in lieu of wages, but to pay the compensation for the injury sustained to him. So this scheme is not compensated because you are getting some wage, or because you are a part of the employment, or you are an employee of that establishment. No, but this act is applicable only when the person is injured, and then only he can claim for the compensation. Moving to the next slide. The Compensation Act aims to provide workmen and their dependents some relief, or to consider compensation payable by the employers to his workmen in case of accident arising out of and in course of employment and causing either death or disablement of the workers as a measure of relief and social security. So it's very clear. There's nothing to explain in this. So it means what? The workmen and the workmen, or even the dependents. If the workman will die, if there is a death causing out of some employment, then the dependents is going to get the compensation. And if some disablement is happening, so it depends upon the percentage of disability that has occurred, right? So in that case, the workman will be entitled to the compensation. So in that case, it is a kind of a relief, or it's a kind of a compensation, or it's a kind of a social security that is being provided to the workman. Provide for payment of certain class of employers. Provide for payment of certain class of employers to their workman compensation for injury or the accident. The same point is there. To enable the workman to get the compensation irrespective of his negligence. So it means that even if suppose there is a machine and the fencing has been done properly, but then it is the accident has caused because of your negligence, because you are out of your mind, or you are not being properly trained, or something like that. Your intention, you are not being properly managed to do the things. But is still, if that kind of accident is happening, it is it is it will not be a matter of discussion. Okay, so this point explains that even if the accident has occurred because of the irrespective of your negligence, even then you will be entitled for the compensation. It laid down the various amount payable in case of an accident, depending upon the type and the extent of injury. So that is what I was discussing, that what type of accident has occurred, and to what extent. I mean to say, how much is the severity of the injury that has occurred. Okay, so employer now knows the amount of compensation he has to pay, and is saved of many uncertainties to which he was subject before the act came to force. So after the enactment of this act, the employees will be very much clear, or you can say a standard principle or the rule will be there, uh, which will make the employer aware that as how much amount that has to be paid, what will the amount that is going to be payable, okay, what will the extent of severity, and if the extent of severity is more, if the injury is very severe, then again what amount the compensation amount will be there. So this law is actually making the things very much clear. So that was not there when before the act was enforced. So the thing was very much vague, and the uncertainty was there as how much amount that has to be paid or not to pay. Okay, so this act, when it came into force, it brings a little bit of clarity in for the employer to take a decision about the amount of compensation which he has to pay to the workman or the dependent. Now, coverage, scope and coverage. The Act extends to the whole of India and applies to any person who is employed, otherwise than in a clerical capacity, in the railway, factories, mines, plantation, mechanically propelled vehicles, loading, unloading work on a ship, construction, maintenance. So you can see the list is there. Repair of roads, bridge, electricity generation, cinema, catching. So you can see the list is there. So Schedule 2 specifically discuss about those occupations where the hazardous, where the risk is more, where the exposure of accident is there, where the chances of mishappening is there. So this act will cover those occupations. Okay, and the list of the occupation is under Schedule 2 of the Act. See, if I have to discuss about the calculation as how much compensation is going to be as the amount of compensation that will be payable by the employers, which will be calculated in the following way. Suppose in case of death, what will happen? 50% of monthly wage relevant, or 50,000, whichever is more, or will be paid. Okay, and 1,000 for the funeral expense. In case of total permanent disablement, if totally the person is totally disabled, so under that case, Schedule 1 will discuss, has actually explained that 60% of the monthly wage, okay, or 60,000, whichever is more. In case there is a partial disablement, so under Schedule 1, such a percentage of compensation payable in will be actually depends upon the percentage of loss in the earning capacity. In case of partial disablement, partial permanent disablement, so in that case, the proportion to the loss of earning capacity. So there's a long list which I have already shared with you in the detailed PPT. So calculations of compensation is actually made on the basis of 2-3 things. First, in case of death, there will be different calculation that I have told you about, the 50% of monthly wages of 50,000. In case of permanent disability, the amount is different. In case of partial permanent disablement, in case of temporary disablement. So in case of temporary disablement, what will happen? The amount is actually equal to 25% of the monthly wages for the period of disablement of 5 years. Okay, so for 5 years or whichever is shorter. So in that case, you can calculate the compensation of for the injured person. Now moving if I have to discuss about the major provisions of this act, see what I've written. The main provisions of the act are: the employer is liable to pay the compensation, number one, if personal injury is caused to workman by accident arising out of and in course of his employment. If and workman employed in an employment contract any disease specified in the act as an occupational disease peculiar to that employment. Okay, so both the points are a little bit different. See, in the first point, the discussion is about any kind of accident which is occurring arising out of the employment. The second point is discussing about the any kind of disease which has happened to the which has any kind of disease with which the workers is infected, and that disease is caused because of his engagement in the employment activity. Okay, I can give a small example to you, like if the person who are employed in the chemical industries, or where the chemicals or acids are being formed, or where the cement factories, you can understand there is a lot of precautions which are being taken by the workers. There are different kinds of dresses, or different kinds of safety rule which are being explained to them, so that uh, they will not get infected out of any disease, right? So even if such diseases will happen, it is this act will actually provide a relief to the workers, and a specific amount of for compensation will be given to them. Now, moving to the next point, however, the employer is not liable to pay the compensation in following cases. So, what are those cases? If the injury does not results in the total or partial disablement of the workman for a period exceeding 3 days. Okay, so if any kind of employment injury that has not occurred within the 3 days of the accident. So after 3 days and 4 days, if person will come with a disablement or with a total or a partial disablement, then this provision will not be applicable. So if there is an injury, you need to report about that injury in the specified period of time. Next, if the injury not resulting in death or permanent total disablement is caused by the accident, which is directly attributable to the workman having been at the time of accident under the influence of drinking or drugs, the willful disobedience of the workman to an order expressly given, or to a rule express framed by the purpose of securing the safety of the workmen. See, these lines are very, actually this is a law, so you have to a little bit write in that language in which these laws are actually written. Okay, so the next point is that uh, if there has been no death, okay, if out because of the accident there has been no death or no permanent disablement has occurred, then in that case the workers will not be liable to the compensation. If the workers is actually performing his job after drinking, and or he has taken any kind of drugs, or any kind of liquor or alcohol or any kind of thing in which his body will not be in control. So in that case, the organization will not take care of, will not consider his claim, right? So if the accident has occurred because of the person is under the influence of drink and drugs, then this law is not applicable. Now, if the workman is not following the rules which is expressed, suppose if you have to wear the helmets, you have to be proper, you have to wear the gloves, or mask should be there, or any kind of boots you have to wear, or helmets with torch and all that. And if the person is not following that rules, so of course the person will not be getting any kind of compensation. Obviously, the role of the supervisor is there. I will not deny on that. It is a role of supervisor or the immediate person who that workman is reporting to take care of all these things. But still, if the rule is not being followed or not be abided, so in that case, the workers will not be getting the compensation. The willful removal or disregard by the workman of any safety guards or other devices which has been provided for the purpose of securing safety of the work. So if any kind of instructions or any kind of safety instruments or devices which has been given to you and you are not wearing or using that, so in that case, this act will not cover or will not consider the claims with which the person will come forward. The state government may, by notification of the official gazette, appoint any person to be the commissioner for the workman compensation for such area as may be specified in the notification. Any commissioner may, for the purpose of deciding any matter referred to him for decision under this act, choose one or more person possessing special knowledge of any matter relevant to the matter under inquiry to assist him in holding the inquiry. So obviously, the state government, by the notification of official gazette, there will be a person who is going to be appointed as a commissioner for the workman compensation, whose work, whose position is actually being notified. And the purpose of selecting or appointing the person is that that person will properly take care of the will properly inquire the matter. He will hold the, he will take the decision which is being referred. Okay, so after gathering the relevant information about the total incident only, or the any matter which is related to that injury or something, if some accident has occurred by the act of some other person. Okay, if I have met with an accident not because of my own reason, but because of the negligence of the manager, or it may be due to the personal enmity with someone, so that is going to be inquired properly. So the reason of accident or the reason for that happening will be properly inquired, right? The compensation should be paid as soon as it falls due. In case where the employer does not accept the liability for the compensation to extend the claim, to the extent claim, he shall be bound to make provisional payment based on the extent of liability which he accepts, and such payment shall be deposited by the commissioner or made to the workman as the case may be. So this point actually discuss about the responsibility to make the payment, to make the liability of the compensation which is there, right? So so it is the duty that after the proper inquiry, the compensation has to be paid to the person who is claiming. Okay, and in case there is some due, or the employee is not able to pay the compensation to the extent the claim has been made, so in that case he will be bound to make the provisional payment based on the extent of liability which he accepts. So obviously the liability with the employer will be there. It's not that the employer will not pay or will skip this or will not provide such kind of relief or social security to the person. Obviously it will be there, right? Now, if any question arises in any proceeding under this act as to the liability of any person or pay the compensation, as to whether a person injured is or is not, or as to the amount or the duration of compensation, the question shall in default of agreement be settled by the commissioner. So there are different parameters on which the commissioner will have to think. The commissioner will take a decision as how much the liability is there with the employer to pay the compensation. Okay, so how much, what is the extent of injury that has happened? Okay, what is the amount of compensation, or if some specified period is there, then how much the employer will get, during what period paid to the person. So all these things will be settled by the commissioner. Oh my God. I've written so much in the PPT, no? But then it needs to be explained properly. I'll not skip all this. These are important. Right. The state government, I'll just read out this. If you have any questions, we can solve that. So the state government may, by notification in the official gazette, directs that every person employing the workman, or that any specified class of such person, shall send at such time and in such form and to such authority as may be specified in the notification, to correct the returns, specifying the number of injury in respect of which compensation has to be paid by the employer during the previous year, and the amount of compensation together with such particular as such the compensation and the state government may direct. So you can understand that the state government, by the notification of official guide, there's a proper manner, there's a proper rule in which the proper notification is there as how much the employer will have to pay, Okay, during what period, when that incident has occurred, how much amount of compensation that has to be paid. So it will all be as per the direction of the law which is there in the act. So a proper see, apart from all this thing, I would also like to make a point here that this is the last slide. Okay, so it is also the duty of the factory, of the employer, to make the people understand about the different provisions, right? Before the not with the I must want to make a point here that if the workers are there or the laborers are there, the responsibility is more with the employer, right? Because they are not that literate or not that technically sound. They are hardly doing some diploma or things like that. So in that case, it is very much important that that person need to be informed about the different provisions of the law, uh, not only about the security which he will be getting, but he need to be also explained about the different safety precautions that which the person have to take, right? Because this compensation does not guarantee that every time if such kind of things will happen, if the person is coming to the office premises by taking some drugs or by drinking, then that will not be entertained, right? So in that case the employer is obviously responsible to pay the compensation, but then accident has to be there, okay, or a death has to be there or disablement has to be there. So that this relief and social security is not by the virtue of the employment that a person is doing, but it is because, but this workman compensation is applicable because of some occurrence of some injury or an accident, and that too because not because of the negligence of the person. Okay, if intentionally if someone is committing something, so that will take up, right? So my point is there as a uh, as a learning, you can understand that this social security division, which is formed under the Ministry of Labor and Employment, actually deals with the social security policy of the workers. It's true, but then it has to be understood that in what provisions, in what circumstances the dependents are going to get the benefits, right? What percentage of disablement will entitle the person to take the benefit, okay? Not only that, but he also need to understand about the about little bit of calculation as how much the person is going to get the compensation, right? Because I told you that there are three categories, there are three things. First is the nature of injury. Okay, I discussed with you that what kind of injury that has happened. The another thing which I discussed with you about the average month wages, how much the person is getting, and about the age of the compensation. Okay, so this is how we have come to the end of this chapter. But then if the time allows me, if I think more 7 minutes is there, 7 to 8 minutes is there, I can discuss a small topic with you, that is misconduct. Okay, misconduct is another chapter for which I would like to make a small discussion with you all. It is also important for you to understand. It is related with this topic, so that's the reason it came into mind. Why not to discuss that? So, what is a misconduct, students? Misconduct can happen anywhere, right? It can happen in any kind of employment in establishment. It can happen in any kind of office or any kind of workplace. It means what? Simply it means that the principles of disciplines are not being followed, right? In a layman language, if the person is not following the rules or the laws, or giving a reason to the employer for the dismissal, right? For you can for taking any kind of disciplinary action by the employer, then the misconduct will happen, right? So if any kind of misconduct is happening in the organization, then what are the different provisions which are there in the law? First thing is that you need to explain to the person that what are the things which will be, what are the points, what are the disciplinary, what are the code of discipline which the employee will have to follow, right? Then, so that has to be written first of all, because you cannot go by just by verbal explanation of certain things. So it has to be properly explained to the person. Now, in such a case that if misconduct has happened, so in that case, what will happen? A written letter or an issue, or a letter will be issued where the advice will be given about the problem that has occurred on the part of employee. Okay, so a person will be given a written warning for the consistent misconduct which is happening. So in that case, otherwise, what will happen? He will be informed that if such kind of workplace indiscipline is going to concern, then what will be the consequences? The employer should also set out the clear disciplinary rules that stipulates how the employee should behave at the work. Okay, all employees should be informed about these rules through, it can be done through the induction program. It can be, the rules can be notified in the notice board, or even through the meeting. So the code of good practices will have to be explained to the person. Okay, because it is the duty of the institution to make, to take, to take a very fair and a reasonable procedure and a reasonable decision also. Because if you're taking an action against some person, obviously you are going to take a, that I mean to say his career is going to be affected, right? So on your behalf, thinking from the employer side of point of view, it is very much important that whatever rules, whatever disciplinary points which the person has to follow, that must be totally explained to him, so that in future that person will adhere that or will follow that. Okay, then the person who is decided on the fairness of a dismissal should consider whether or not the employee broke a rule of conduct in the workplace, the rule was valid or reasonable, the employee knew about the rules or should have known about the rules. The employer has to consider consistently, will have to see whether these rules are being followed or not. So dismissal is actually appropriate step only when taken against an employee, only when the employee is breaking the rule which you have explained to them, or if the employee is not following the final written warning which you have given, or the warning of suspension which you have informed to the person, right? So if there is a repeated offenses that has been taking place, so that will not be justified on the part of management also to overlook. Okay, so in that case it is very appropriate that the employee has that a proper action must be taken against that employee. Because what will happen that once the disciplinary actions will be taken, it's give a message to the entire employees group that the employment that the employer is not going to tolerate such kind of misconduct or such kind of indiscipline, right? So whenever, and see, there are certain kind of employees who are very dedicated, right? They are coming to the office in time, they are very much punctual with their job, right? They are very much particular about their performance, their conduct in the workplace. They are well behaved with the ladies and with the other staffs. So in that case, what message you are going to give to them if you are overlooking the misconduct of the other employees? So in that case, it is also the responsibility of the management to be committed on the rules which at the time of induction you have conveyed to the employees. Okay, so the now one small thing I would like to discuss with you. Like, now you may have a question that, ma'am, what are the different, can you give some examples of serious misconduct? to start with, see, if there is some dishonesty which is happening, if there is some fraud which is happening, right? If there is any kind of physical assault which is there, physical assault means that you are being forced to do the work after your work hour is over, or you are doing a work, straining your body, straining your eyes, hampering your personal life, and you are being asked to come to the office after the work hour. So sometimes, see, what happens that it is the requirement of the job. You by yourself, you will find that sometimes the job demands that you have to very much committed, punctual, and beyond the hours also you have to work. But then it is very much important also that work, your personal and professional life balance has to be there, right? So that can be a choice by you. You want to give, you want to work beyond the working hour, that is up to your choice. But the management or the organization can't force you, can't take you to that extent where your physical torture is happening or your mental balance, your mental peace is hampering, right? See, so what I discussed with you about the gross dishonesty, example, the frauds, physical assault, right? So the next can be like any kind of sexual harassment which is happening. There is a unwanted sexual desire of the person, uh, and if you are not agreeing to that, and if something is happening without your will and wish, then that will come under the offense, right? So you have to understand that thing, that you have to take a proper decision, judgment on the merits, and on the judgment on the nature of the misconduct which has happened, the involvement of the person himself, and the role and the fairness of the management on part of explaining the employees that what are the things which will be covered under misconduct or not be covered, right? So in addition to good substantial reason for dismissal, the employer is required to follow a fair procedure when dismissing an employee. So employer need to make an investigation into, first thing is that you have to investigate the alleged misconduct, right? The requirement is that the employee must be informed about the charges. It is not fair that I'm charging you and you are not aware that for what reason you will be penalized or you will be dismissed, right? So employee must be informed about the charges in the manner she or he can understand, right? So it has to be a fair and transparent, or a very one-to-one discussion has to be there. The employee should be given sufficient time to prepare for the hearing. Okay, so you have to give the proper time to the employee to prepare himself so that he will answer to your questions. It's not like that in a meeting you're calling someone, you start shouting at that person and you want the person to, if something is related to, if the offense or the misconduct is very serious, you may have to take that person into confidence and you will have a discussion in one-to-one way, right? So proper timing up is very much important. You have to give time to the employee to think, uh, and he will give a submission. The union should be consulted before commencing an inquiry, right? As an employer, you cannot directly go to the employee. See, if some union is there, obviously, sometimes the employee's problem are well represented by the union also. So the employee must be given a chance to state his or her case. You have to give him a proper chance so that he can explain what is his state or what is his statement and what was the situation that has forced him to do such kind of act, right? After the inquiry is over, the employer should notify the employee in writing of the decision with a clear reason. You have to make the employee very much clear about the decisions which you have taken. It can't be in a vague that you're saying someone not to come to the office for a week, and after that you are just giving a telephone call and this saying that from tomorrow you won't be coming. You are not allowed to enter the office premises. So that's not the way, right? So if you have undergone an inquiry, if a proper investigation has taken place with a proper inspection into the matter and all that, it is the duty of the employer to properly notify the employee in a writing that whatever decision the management is taken, why it is taken, or what is the reason behind such decision. Okay. So if the employee and see if the employee is not satisfied after being dismissed, see if the employee is not satisfied after being dismissed, the employer has to inform the employee of his and her right to appeal, and thereafter to refer the matter to the relevant council, right? So if the employee is not happy with the decision the employer has taken, or is thinking that the employer has not taken a decision which is very much fair, which if the employee is thinking that the decision is not fair on his on the part, okay, then you cannot stop the employee to go to the go and seek some next stage, right? So in that way the employee can go to the next agency, can go, but that process has to be taken within this 30 days. Okay. If it is later done, within 30 days, if that decision is not being taken, not being objected, then the employer will take that decision, right? So in this way, today I have discussed with you regarding the Workmen Compensation Act. I discussed with you the different provisions, like Workmen Compensation Act is applied to whom and in what circumstances, what are the different ways of calculating the workers' compensation, right? I've also discussed with you all the different objectives of the act, like this act is applied to which like in what situations this act are going to be enacted. Then I've also discussed with you the different schedules, like different organizational setup which will take up this compensation, right? Like I've discussed with you, like in Schedule 2 of the Act, the Act is extended to the whole of India. I discussed with you, like in different employees who are working with railway factories and who are working with the in the hazardous occupations, they will be covered under this act, right? And I'd also discussed with you the different provisions that like for if the injury has happened to 100%, then what will be the provision? Okay, if the employee is having a partial disablement, then what will be the situation in case of death? Okay, or in case of permanent total disability. So in this way, and I'd also discussed with you regarding the different precautions or the different uh, provisions which the employee also need to understand. Like if the employee is going to the office by drinking or by taking any drugs, okay, if the person is not taking care to properly wear the different kind of helmets or the safety precautions which is being explained to the person, so in that case, the person will not be getting the relief, or he will have no claim over the compensation, right? So with this, I've come to the end of the class. Like if you have any questions, you can ask me. Okay, with the like we have the limitations of time here. So I decided to discuss only one topic, but then I have covered two topics with you, like misconduct and also in the last class I discussed with you about the which topic you remember? I discussed with you about the industrial dispute. So I request the students that if you have any problem relating to the topics which I've discussed with you, you can text me, right? You can give me a mail You can text me in the WhatsApp also. I'm available every time. So mm, this is how, and I would request you to go through the PPTs which I had already shared with you. I believe that you have up and downloaded that from the Swadhyay portal. So anytime, please, because your exams are going to come next week. So be prepared, and you are most welcome with your doubts and queries. Uh, so because a class should not be